but this detective already did the analysis. Now we just need the lab to process it. And that would be my objection, is that, wait a minute, my client is accused of murder, and there was a handgun found in the decedent's close to his body, and his hands were
Romero Espinoza. Deputy Laura, I'm trying not to jinx us, so I'm not going to roll my R's. I could roll my R's, but I choose not to. All right, so where are we on this case?
Well, Judge, we are at discovery, and there is quite a bit of discovery. And I conferred with the state, and we've found out some items that the state's going to look into.
Okay. So state, is there anything that you're aware of that's outstanding?
So what we're concerned about are the videos that were taken by SAPD. The update that I had for the court regarding the laboratory is that there was a gunshot residue that was taken from the complainant, but I've spoken with the lab to see if they could expedite that, and they stated to me that due to their policy that they're not going to be processing it once it is open. It's just going to be closed out because the person that it was taken suffered from a gunshot wound, so it's not processed.
Okay.
Your Honor, may I address that?
Yes.
I read a police detective's report.
Let's do this. Let's go on the record.
Okay.
All right. That way everyone is covered. So the court is calling 2026 CR 005225 State versus Romero Espinoza Jr. Can I have parties announced?
Megan Galloway for the state.
J.D. Garza defended Mr. Espinosa.
And are you Mr. Espinoza?
Yes, Your Honor.
All right. So off the record, we were talking about discovery in state. You said there's some videos from SAPD, and then there's laboratory report for gunshot residue that was taken from the complainant. And you reached out to the laboratory, and what information were you given?
Yes, Judge. So during the course of this investigation, there was a gunshot residue sample that was taken from the complainant. It was sent to the Bexar County Crime Lab. I did reach out to their administrator to get a time estimate on how long it would take to complete that analysis. When she pulled up the case to look, I had explained to her that the sample was taken from the complainant in the case, and she informed me that the lab would not be completing the analysis due to their policy that they do not complete analysis on people that have sustained gunshot wounds. And so she relayed to me that once the case was pulled into her queue to work it, it would just be closed out without analysis because the person sustained a gunshot wound. I explained the facts and circumstances of the case to her and asked her if she could conduct that analysis in this case, and she said no.
Well, does an order need to be signed? Do you want the?
Well, Judge, that is where I'm opposed, because the night detectives, they understand that there's a gunshot victim. We don't do gunshot residue, so why even process it? In this case, he was processed, and so I understand their policy, but this detective already did the analysis. Now we just need the lab to process it. And that would be my objection, is that, wait a minute, my client is accused of murder, and there was a handgun found in the decedent's close to his body, and his hands were processed by the detective. Why does that policy keep the lab from completing that analysis? And I would request a court order for him to be done. Otherwise, the jury, if we go to trial, they're going to be left with a big question. What was the result of that? Because they are going to hear about the policy that doesn't allow them.
All right. So this is what needs to happen. The person who is assigned to do the testing, they need to be subpoenaed to come to court and we'll have a hearing.
Okay,
All right,
that
so
would be a pretrial hearing, right there.
yes, so I'm going to set this for pretrial and hopefully you all let them know not to destroy anything.
Yes, Judge, they wouldn't, since the sample was taken, it would just be closed out and sent back to the property.
All right, so I'm going to recall this for hearing 30 days. Is that enough time or you all need more?
In advance.
All right. Norma, I need a date in September for a discovery hearing.
I can do that September 10th on a Thursday.
September 10th?
Yes.
Well, I mean, not on a Thursday. We need it on like a Monday.
Do it.
The 14th?
All right, September 14th.
Back in the morning or the afternoon?
Afternoon.
I don't even know who that person is, Judge. Can the state notify
They'll
them?
let you know who it is. Is that not a good date?
I'm just checking what's going on.
All right, y'all want to do it at the beginning of October?
Judge, yeah, because I'm unavailable on the.
All right, let's put it at the beginning of October. What date? Is that a Monday? All right, October 5th. And
Oh.
counsel, if you'll let defense
Judge,
counsel,
excuse me, the 5th is a Saturday.
October.
Oh,
October 5th.
I'm sorry.
All right, if you'll let him know the name of the person he needs to subpoena. All right, so we'll be back on October 5th.
Oh.
All right, see you back then. Once you sign the reset form, you're excused. Thank you for dressing appropriately today.
Thank you, Your Honor.
You're welcome. Just have a seat and your attorney will bring the reset form to you. Yes.
Judge,